Mr. Stevens told you 100%, I will give her consent right now to her, correct?
Yes.
That's it. There's no going back. Once you refuse, you refuse.
Deputy, that's your voice saying once you refuse, right?
Yes.
What other remedy is there other than dismissal? All right, we'll go ahead and call the People versus Kevin Stevens. We have the motion to suppress and dismiss. Do the people want to make a brief argument on the motion before they call a witness?
No.
Okay, Mr. Callaway.
For your honor, I'll just reserve closing argument after the deputy's testimony, sir.
So it looks like a pretty limited area for the motion to suppress if we can keep the testimony limited to that area, Mr. Yancey.
Yes, your honor.
People's first witness.
Yes, your honor. Can I grab the move hallway?
Who is it?
It is Deputy Matthew Peace.
Deputy, if you'll come up in front of me and raise your right hand. Do you solemnly swear or affirm that the testimony you give before this court will be the truth, the whole truth, and nothing but the truth? You can have a seat right over there.
Deputy Matthew Pease, P-E-A-S-E,
And where are you currently employed?
the El Paso County Sheriff's Office.
How long have you been employed there?
Since 2019, about a little over 7 years.
And what training did you receive with the El Paso County Sheriff's Office?
I went through 2 academies, a non-certified academy and then a post-certified academy. In that academy, we do standardized field sobriety testing. And then I went on to do more training for ARIDE, which is the advanced roadside impaired driving testing. And then after the academy, when I was on patrol, I became an SFST instructor for the academy.
Were you on duty the night of January 23rd leading into the morning of January 24th, 2026?
Yes.
And what happened that night a little after midnight?
We got a call for check the welfare. The reporting party said that there was a vehicle in the intersection of Galley and Hathaway. And they saw the light signals cycle and the car not moving. So they asked us to go check on the vehicle.
And that was the defendant being read as express consent under Colorado law, correct?
Yes.
And that was Deputy LeBaron who read that to him.
Yes.
And after that express consent advisement was given, what test did he elect?
Blood.
And where did you take him for the blood draw?
Memorial Central Hospital.
Did you have to request the phlebotomist to come down and draw Mr. Stevens' blood?
Yes.
And from what we just watched, Kevin Stevens refused the blood draw from the phlebotomist.
He did, yes.
And the phlebotomist mentioned that once she heard a no, she would leave.
Yes.
Was the phlebotomist the individual who asked for consent for the blood draw when they were in the room?
She was, yes.
And was the no in response to a question, may I draw your blood from the phlebotomist?
Yes.
And are you out of the hospital at this point walking back to your squad car?
Yes.
And you are not in the room with the phlebotomist?
No.
And this was after the phlebotomist asked, do I have your consent to draw your blood?
Yes.
When Mr. Stevens told the phlebotomist no, did you take that as a refusal?
I did, yes.
And why didn't you take him back in to complete the blood test?
Because he refused the original blood test.
We have no further questions, Your Honor.
All right, cross-examination.
Good afternoon, Deputy.
Gotcha.
You were the arresting officer in this DUI investigation, correct?
Yes.
And you were the deputy who completed and signed the express consent affidavit, right?
Yes.
And we just saw that you had your body-worn camera on, activated, and functioning properly, correct?
Yes.
It captured your interactions with Mr. Stevens.
It did.
And your body-worn camera recording displays timestamps in the top right corner, right?
Yes.
And you agree that each one of those clips that you viewed fairly and accurately depicts your interactions with Mr. Stevens, correct?
Yes.
Your Honor, the defense would move to admit exhibits A through D into evidence.
Any objection to A through D?
No, Your Honor.
A through D will be admitted and we can publish.
When Deputy LeBaron gave Mr. Stevens the express consent advisement, Mr. Stevens elected a blood test, correct?
He did.
He did not refuse chemical testing during that advisement, right?
No.
And you transported Mr. Stevens to Memorial Hospital because he had elected blood, right?
Yes.
You didn't take him there because he needed medical treatment.
No.
And you arrived at the hospital at approximately 12:51 a.m., correct?
I'm not sure the exact time, but that's what the body cam shows, yes.
Would watching portion of your body worn camera refresh your recollection as to what time you arrived at the hospital?
Yes.
So for the record, I've published what's been admitted as Defense Exhibit B. It's kind of cut off at the top, Deputy Pease, but if you look at the top right corner, can you see a timestamp up there?
I can't, but that's the body cam, so the time is accurate.
May I approach?
Yes.
Deputy Pease, is that your body worn camera footage?
Yes.
Can you see a timestamp in the top right corner of that?
It'll be
What time is it in the top right corner?
12:54.
So your arrival with Mr. Stevens at the hospital was well within 2 hours of your contact with him, right?
Yes.
Because when you first contacted him, it was 12:21 a.m. Does that sound right?
Yes.
When the phlebotomist met with you and Mr. Stevens in the blood draw room, the phlebotomist described the blood test as a legal blood draw, didn't she?
He did.
And she told Mr. Stevens that he could say no, right?
Yes.
And that if he did, she would walk away.
Yes.
Before that point, you had never told Mr. Stevens he could say no.
No.
Deputy LeBaron didn't tell him he could say no.
No.
So for the first time, when the phlebotomist walked in the room, that was the only time Mr. Stevens had heard that he could say no at that point, correct?
Yes.
And Mr. Stevens told the phlebotomist that he did not know it was a legal blood draw, right?
Yes.
And when she asked him again, she characterized the blood draw as a legal blood draw, right?
Yes.
You never told Mr. Stevens he was going to the hospital for a legal blood draw, did you?
I did not know.
Deputy LeBaron never told Mr. Stevens it would be a legal blood draw.
I don't believe so.
In fact, no deputy told him that.
No.
And that's when Mr. Stevens uttered the word no, correct?
Yes.
And that was the first time he had ever said no to the blood test.
Yes.
And you immediately treated that answer as a completed refusal, correct?
I did. Yes.
And so you escorted him out of the room and toward your patrol car.
Yes.
No hospital employee told you that Mr. Stevens' blood could never be drawn if he changed his mind, right?
No.
No medical professional attempted a blood draw and failed, right?
I mean, besides, you mean like actually?
No one put a needle in his arm and couldn't
no.
find a vein.
No. No.
And you didn't ask the phlebotomist whether she could return if Mr. Stevens changed his mind, right?
I did not know.
Okay. And the conversation about the blood draw continued as you and Mr. Stevens walked outside, didn't it?
Yes.
This is your body worn camera where you and Mr. Stevens are just right outside the hospital doors, right?
Yes.
Mr. Stevens is not yet inside your patrol car.
No.
You obviously had not started your patrol car or begun driving away at this point, correct?
Back to your seconds. No, I did not. She said, you give me consent. I said, no. After
You just heard Mr. Stevens say that he would give his consent to her, not you, right?
Yes.
And the her in that statement was the phlebotomist who had just asked to draw his blood, right?
Yes.
You were not the person who would insert the needle or draw the blood, right?
No.
And at this point, Mr. Stevens was agreeing to the same blood test he had elected at the scene when Deputy LeBaron asked him, right?
Yes.
Mr. Stevens told you 100%, I will give her consent right now to her, correct?
Yes.
Mr. Stevens didn't ask to switch from blood to breath.
No.
Didn't ask for more time to decide which test to give.
No.
He didn't ask you to leave the hospital and take him away.
No.
And only a few minutes separated his initial no inside the hospital from his agreement to consent right now outside, correct?
Correct.
Less than 3 minutes.
Yeah.
And you continued discussing with him whether that blood draw would occur.
Yes.
You remained actively engaged with him during that discussion.
Yes.
And the only thing you two are talking about right now is the blood draw.
Correct.
And so at that point, your entire DUI investigation was less than an hour old, right?
Yes.
The hospital doors remained open.
Yes.
The phlebotomist didn't tell you that her shift was ending.
No.
No one told you that another qualified phlebotomist was unavailable.
No.
No medical professional told you that Mr. Stevens' blood could not be drawn.
No.
You weren't dispatched to an emergency that interrupted the blood draw process, right? You hadn't left the hospital yet to book Mr. Stevens into jail
No.
or to resume your patrol duties.
No.
In fact, you hadn't even served him the express consent affidavit yet.
No.
I mean, you didn't even start filling it out, right? So there was still time and opportunity.
I said no. Sorry, I'm a little quiet.
And just so that I'm clear, no, at this point, you had not yet begun filling out the express consent
I
affidavit.
have not, no.
So there was still time and opportunity to complete the blood draw if you had allowed it, right?
Yes,
And the hospital doors are just steps away from where you're standing.
correct.
So you could have turned around and taken Mr. Stevens back inside to do the blood draw, right?
Correct.
And despite Mr. Stevens' statement that he would consent right now, you decided that you would not take him back inside.
Yes,
And so you place him in the patrol car, right?
yes,
And you continued talking with him about the blood draw.
yes,
I'm publishing what's been admitted as Defense Exhibit D.
Yes, she walked in. She said, this is a legal blood draw. You didn't consent to draw your blood. You said, no. And then she walked away. No, because you already refused. We're not going back there to call her back to play the games. Or you refuse, that's it. There's no going back. Once you refuse, you refuse.
Deputy, that's your voice saying, when you refuse, that's it. There's no going back. Once you refuse, right?
yes,
And that was your understanding of the law at the time, wasn't it?
that was, yes.
Did Deputy LeBaron teach you that that's Colorado law regarding express consent?
No,
Objection, Your
Relevance.
It's relevant to his knowledge of what the law surrounding express consent was in Colorado at the time that he and Mr. Stevens were engaged in a conversation about the test.
Then rephrase the question and ask where he got his knowledge.
Who taught you the law surrounding express consent in Colorado?
it was taught in the academy and just reading the express consent
Okay.
paperwork, I guess.
Have you ever read the express consent statute?
I have, I can't tell you it off the top of my head.
Are you aware of any case law in Colorado regarding express consent?
As of today, yes. During that time, no, I was not.
So as of today, you should know that once someone initially refuses, that's not the end of it, right?
Yes,
You've gained knowledge about the law surrounding express consent since this event, correct?
correct.
You now know that someone can revoke their refusal, right?
Yes,
And you know that under express consent law, you are obligated to give the driver their elected test.
correct.
But you didn't do that here.
I did not.
And you didn't reject Mr. Stevens's renewed consent because the 2-hour period had expired, right?
It did not, no.
And you know that a person must give a blood or breath test within 2 hours after driving.
Yes,
And again, we were not past the 2-hour mark here.
no,
We weren't even past the 1-hour mark.
no.
From the moment that you contacted Mr. Stevens to the moment you put him in your patrol car and drove from the hospital, it had been a little over 30 minutes.
I'd say, yeah, roughly.
So you rejected Mr. Stevens' consent because in your view, the first no ended the matter forever, right?
Correct,
That there was no going back.
correct.
And so ultimately, no blood sample was collected from Mr. Stevens' arm, right?
No,
And the only reason there's no blood sample in this case is because you decided not to honor Mr. Stevens' choice to give his consent to the phlebotomist right now, right? Deputy Pease, while you were standing in that blood draw room, you had to open a cabinet to retrieve the blood collection kit, didn't you?
yes,
The cabinet that you had to open is that cabinet in the top right, correct?
correct.
There's a sign on that cabinet, isn't there?
Believe so.
Can you see it?
Yeah.
Nope. You're right.
Oh, yes,
You saw that sign when you were standing in that room with Mr. Stevens, didn't you?
yes,
And it says, remember, blood is evidence, right?
correct.
You agree that in a DUI case, blood is in fact evidence.
Yes,
So you didn't collect that evidence, did you?
I did not.
Those are all the questions I have for you, Deputy. Thank you.
Thank you.
Is the term a legal blood draw what you use within law enforcement?
I do not know.
Do phlebotomists and hospital staff work for law enforcement?
They do not.
And did the phlebotomist ask for consent to draw his blood?
She did.
When you were walking out of the hospital, is your DUI investigation over?
No.
Is the right to recant or refusal absolute?
Your objection, I don't think there's been foundation made for him to be able to answer that.
Your Honor, the defendant laid his own foundation when the defense questioned him as to his legal knowledge of the refusal statute and the recantation case law.
For purposes of this hearing, it's a whole, you can answer that.
Is the right to recant or refusal absolute?
I'm not sure.
Yeah, we are done.
You have no further direction.
No further direction, Your Honor.
So Deputy, you can step down, and is he released from the subpoena?
On January 24, 2026, Mr. Stevens unequivocally stated to the phlebotomist, no, that she did not have his consent for the legal blood draw. And that was around 12:55 a.m. Under statute 42-4 1301.12a, once the defendant elects the type of manner of test, they must comply. By refusing the phlebotomist consent to draw his blood, he was not in compliance with the Colorado Express consent statute. While the recantation happened within the 2-hour window, Stevens' statement no was unequivocal, expressed to the phlebotomist that she did not have his consent to draw the blood. And if the court were to find that the recantation is valid and therefore was improper police conduct, recantation does not warrant dismissal or suppression in this matter. And it is up to the court as to improper police conduct. And within the good faith basis, there was no malice for not administering the blood test. There was no bad faith on behalf of Deputy Peace. He brought Mr. Stevens to the hospital. He brought in the phlebotomist and he conducted everything to conduct the blood test. And that is when Mr. Stevens refused. With the refusal and recantation in People v. Montoya, 546 Pacific 3rd, 605 at a pin site of 616, the driver's recantation of the initial refusal in the context of a criminal trial is circumstantial evidence that the jurors may consider along with any reasonable inferences that they may draw from such conduct in reaching a verdict. Under People v. Montoya, the initial refusal and the subsequent recantation should be viewed as circumstantial evidence and a rebuttable inference to the refusal itself in front of a jury. Thank you, Your Honor. That is all.
So if this was Mr. Yancey, if this was a timely recantation of the refusal,
Yes. Yeah.
what other remedy is there other than dismissal of the case? Because you're cutting off Mr. Stevens' right to complete the test and possibly have that test come back exculpatory.
Yes, Your Honor. In Colorado, I apologize. I did not mean to cut you off. Yes, Your Honor. Under Colorado law, there are mutual obligations within the test, and the law enforcement can use the test to prove a level of guilt, while also the defendant can use it to prove any indicia of non-guilty or anything like that. There are mutual obligations in that matter. And in People v. Montoya, the courts view it as circumstantial evidence that should go to a jury when assessing the level of impairment as circumstantial evidence to the refusal and the subsequent recantation.
All right. Is defense, you want to make an argument, Mr. Maher?
I do, Judge. And just on that last point, Montoya 2 didn't address this particular question. For whatever reason, the defense in Montoya 2 did not file this motion prior to trial and discuss Knoll, Gillette, Turbine, and Riley and the effect of not having a chemical test that could be potentially exculpatory as the jury's looking at refusal and the recantation. That just didn't come up. So we're kind of in the same but a different area. And I think the question that you asked, it's important to realize that just wasn't part of that underlying case. Certainly, evidence that would be exculpatory, a blood test, would be quite important in proving why Mr. Stevens recanted. It's quite significant that he doesn't have that evidence because it essentially puts the state in a position where there's a refusal. They don't allow for the evidence that's contemplated in Gillette, Turbine, Knoll, and Riley. And Mr. Stevens can't put on that evidence because he doesn't He doesn't control the investigation at that point. He did all he could do to say, I'll take this test. I have a better understanding of what you need from me and what is required of me, and I'm going to take the test. If you notice from the video, the first time that anyone explained to him, not required to, of course, the first time that anyone explained to him, here's the real process. If you don't do this, you're going to lose your driver's license. You're required to do it under Colorado law. Deputy LeBaron had given a very short, cursory advisement of what you're required to do just in terms of election of a test. But what happens, all of the stuff that's going to occur at that point, as they're standing in the parking lot before he gets in the car, that's the first time that happens. And then a test is elected. So I'm happy to kind of start where I was going to start, Judge, but there's specific questions that you have that would help us get to the point where the remedy here is dismissal, because Mr. Stevens just simply cannot put on evidence that he would have been able to put on had the officer, followed what the law is. He's not doing anything malicious. We're not here to claim that. In fact, we don't have to. That's absolutely not part of what we have to put on at this hearing. That's just, so we're not saying that. What we're saying is the law just wasn't followed, and he is where he is now.
So when I look at Montoya, after Mr. Callaway put it in his motion, the driver elected a blood test. They go to the hospital.
Right.
The driver refuses to let the nurse draw his blood.
Right.
The driver says, I don't think I'm going to do it. 15 minutes later, driver says yes. And this statement is 20 minutes before the 2-hour
Correct.
blood drawn needs to happen.
And that's why I think our case is better, right? We're 1 hour in. I mean, we got lots of time here.
36 minutes in.
Yeah. I mean, so we're less than an hour in. I mean, there's just no reason why we shouldn't be doing this. But Montoya 2 also says, which I think is important for officers like Deputy Pease, we're not going to ignore what's been laid out in Galleon. I mean, that's been good law for a long time. Right? So you can still follow it. And it also allows gentlemen like Deputy Pease to know what should I do and what should I not do. If you're 36 minutes in, you're right outside of the hospital, you haven't written a single scratch on a ticket, you're still engaged in the investigation, he's asking you to do the test, you give him the test and then see what the BAC is. I'm not going to be long-winded. The only thing I would say, Your Honor, is that dismissal is absolutely the correct remedy here, because we are behind the 8 ball now. My client did what he was supposed to do. It wasn't perfect. It wasn't, but it's what the law allows for. And he cannot present his potentially exculpatory evidence, which the court in Montoya specifically says that is material evidence. They say it in terms of the prosecution, but as we know from Knoll, Gillette, Turbine, and Riley, it's material for everybody, certainly for us. So for those reasons, we just can't get back to a place where this is a fair trial. I asked the court to dismiss based on that.
Most of the county court bench knows that case law better than anyone coming out of COVID and having the issues with blood or breath and things like that.
If I can make this part of the record, when the court went through those cases, the COVID litigation, this bench basically, if you didn't get the test, if you were a refusal or marked as a refusal erroneously, then the dismissal was the remedy. If, on the other hand, and this is a proper reading of Knoll, if you did get the test, if you decided to take it, even though that was your only option, you got your potentially exculpatory evidence, which certainly most of the time was not exculpatory.
And dismissal wasn't.
Right. And dismissal was not proper. And we're in, I think, the first bin here.
And so the issue today for the court was whether this was a timely recantation on the recusal. I think that everyone can agree that Mr. Stevens tried to recant. The question is whether or not it was timely. The facts are largely undisputed. Deputy Pease and Deputy LeBaron had contact with Mr. Stevens January 24th of this year after midnight. Defendant consented to a blood draw, said he didn't want to do breath, specifically not breath, okay, then blood. And so the parties went to the hospital for that blood draw. When the nurse describes the procedure as a legal blood draw, Mr. Stevens says no, he doesn't give consent. Deputy Pease is on body-worn camera, sounds aggravated and says something like, well, you could have said that before we drove all the way down here. They're outside of the hospital walking back towards the patrol car, and specifically Mr. Stevens says, I didn't understand what was going on. Deputy Pease says, quote, once you refuse, you refuse. At 12:21, the deputies contact the defendant. They're in the hospital blood draw room as soon as 12:51, so about 30 minutes later. At approximately 12:55, the defendant says he won't do the blood draw. So we're 35, 36 minutes in when he says he won't do it. They're going back to the patrol car, and then the deputy refuses to take Mr. Stevens back for the blood draw after he's already said it. No. Or saw on the body worn camera the defendant say he would give consent to her, meaning the phlebotomist 100%. This was a few minutes after the formal refusal. So the recantation, as argued by Mr. Callaway, was less than 3 minutes from the initial refusal. And the reason I'm spending some time on these facts is because that's what the court has to consider when deciding, was this a reasonable recantation of the refusal? Galleon 171 Pacific 3rd 217 upheld a revocation where the driver refused several times to comply with express consent. They were somewhere between 75 and 80 minutes in to that stop. And that's important because, again, we're just over a half an hour in. And so the whole point of express consent is to give both sides evidence as to a blood or a breath test. And when it's reasonable or timely, the law enforcement officer should take the recantation and give someone a second chance at getting the evidence. And that didn't happen here, which the court is finding is a violation, the defendant's express consent. If this defendant had said, no, I'm not doing this, there was no recantation until later on in the stop, or later on, they're in the patrol car, headed back to the jail, he's going to be processed. That might be a different situation for the court, but here, Deputy Peace testified that he hadn't even begun filling out the paperwork, the express consent paperwork. So he hadn't even started that process. Obviously, the correct thing would have been in the court's mind and under the case laws to, as soon as he said 100%, I give my consent to her, is to turn around and take him back into the hospital. They are outside the hospital. The patrol car has not even been started. The cases, like I said, are specific to the facts, and they're outside a hospital. The court can only conclude if there's still a nurse present and able and willing to give the test. The express consent statute was violated, and Mr. Stevens wasn't afforded the right to take the test after he fully understood what it was and that there was sufficient time to obtain the blood sample, especially when you look at the 2 hours that the police had. So then the next question is whether or not we suppress the blood result or the lack of blood result. We don't have that. And so then we look at what's the appropriate remedy. And because Mr. Stevens wasn't afforded the opportunity to complete the chemical test, and because he was deprived of any kind of exculpatory or inculpatory evidence, then I do agree with Mr. Maher that the Knoll, Gillette, and Turbine cases control. And given that we don't have possible exculpatory evidence, I think that the appropriate remedy is a dismissal. I thought long and hard about the appropriate remedy, and that's when I went back and looked at our decisions after COVID, and then we had just a ton of issues with regards to blood and breath tests. And so, because we don't have the evidence, there's no other remedy that's appropriate. We don't have Mr. Stevens refusing because I found that it was a proper or timely recantation. And so if he refuses, he refuses. He's given up his right to any kind of evidence, but he didn't. And so the court can only find that in this situation with these specific facts, that the case should be dismissed as the appropriate remedy. So the court is going to grant the motion to suppress and dismiss due to the violations of 42.413.01.1 Is there anything additional from the people?
Nothing further, Your Honor. Thank you.
Anything from the defense?
Nothing from the defense, Your Honor.
So, Mr. Stevens, this was a legal ruling. You need to be careful in the future with the choices and decisions you make. Your readiness and trial dates are vacated.